Clayton Cosgrove.
Mr Chair, I just want to raise a couple of very quick questions, and they may seem simple on the face of it in regard to 43B et al. But could the Minister or officials advise us whether any of these provisions in terms of non-active trusts being excused from filing returns differ from the status quo? Because as I understand it, a non-active trust, that is a trust that's not making income, would simply in writing advise the IRD Commissioner that, for instance, they owned a property that perhaps the beneficiary or settlor lived in, that there was no rent being charged, there was no money changing hands, they just simply owned an asset on behalf of the beneficiary, therefore there was no income being made, nothing being charged, no expensing, zero, they were non-active by definition, and they would advise the IRD in writing, and that would be it. They wouldn't have to file a return until they did become active. That's, if I'm wrong, please feel free to correct me, but that's my limited understanding. So my question simply is, are there any deviations from either my interpretation of what the status quo is, or if the status quo is different, is there any difference from that? Because, as we've pointed out without labouring the point in part one, there are substantial differences in definitions which don't exist or aren't consistent or coherent with other tax acts, the Income Tax Act or the Land Act. And my question simply is, do these differ from the status quo? Because on the face of it, and my colleagues have raised some valid points, but if there is an advantage, as we've sort of tried to communicate, in some sorts of consistency from the Income Tax Act to this piece of legislation. So it would give some comfort if the Minister could advise if the same scheme of arrangement that has existed outside this piece of legislation in terms of non-active trusts exists within it. If it does, I suppose at least it's consistent with case law, it's consistent with other pieces of legislation. Now, I mean that in good faith. I think it would be helpful to get on the record of the House. Likewise, in respect of the other matters here in terms of deductions and other bits and pieces, are they consistent with existing law, other than obviously dollar amounts? My colleague raises an interesting point about the $50. I note that in the report to the FEC from submitters, KPMG submitted on the net filing income threshold for individuals, and said that the $200 non-filing income threshold for individuals had been unchanged for over 15 years, made the same point, I think, as my colleague. Therefore, it's timely, they said, that it increased to take into account of inflation, and they proposed a net income threshold of $500. So again, in respect of trusts, is there any movement in that? What's the justification for the $50, or has it just been plucked out of, thin air? Or is it consistent with any other pieces of legislation? So, in essence, sir, those are the basic questions. And as I say, I do note Trevor Mallard's ruling that debates continued. Maybe it was a groundbreaking ruling, I don't know. But last week made it very clear that if ministers were prepared to answer questions, then that may aid in the efficiency of debate and conclusion. But where ministers didn't, then these were very serious questions, then that didn't aid the debate or contract its longevity. So, as I say, the simple question is, are these provisions for non-active trusts consistent with the status quo? Very simple. I think it would be helpful actually to get on the record of the House these issues are, and Hansard is quoted in case law and is quoted in the courts. And if it's not consistent, then what would be helpful is to outline what the changes are and why, and what the justification for those changes is. I think that's a reasonable request to make, given that there are a plethora of family trusts around the country. Many folks have them. Again, one or two people pull the wool, but they're normally set up for very, very good reason in respect of protection of family assets, protection against being sued or whatever, risk management. It's very difficult now, I would say, I'd argue, not wholly, not totally difficult, but it is reasonably difficult to pull the wool if the IRD is actively looking at these trusts. And on that point, it would be helpful to know that if these rules differ, so if they differ from the status quo, is the IRD, Mr Chair,
The Honourable Clayton Cosgrove.
is the IRD going to embark on any special policing, any special auditing, any special legitimate interrogation of trust arrangements to ensure, especially under this piece of legislation, that if they're not active, they really are not active? Now, you can make an argument to say, well, if you put in writing to the IRD that it's not active, you're not making income, you're just like any other taxpayer, you're committing fraud, you're lying if you say no income and there is income. That's true, but I would have thought, given this is a new piece of legislation, that the IRD, if, again, they're very serious about cutting down on speculative investment, that they'd be running the ruler over many of these entities, just not in a nefarious way, but to ensure that people are complying with their obligations. So, Sarah, I simply raised those questions, and I would hope that the Minister may be able to give us some sort of answer to them.